Yeah, what don't we do?
What don't we do?
Well, we're going to talk about family law.
Any information that we talk about is not legal advice.
That's right, and it shouldn't be construed as legal advice. You might construe as legal advice, and that's on you.
That's right. I'm John.
And I'm David.
So, what beauties have you got for us today, mate? What have you found?
Okay, so another post on the family law support in Australia, chat group, I guess, in Facebook. Here is the question from anonymous member. Does a 12 turning 13-year-old have a say on custody of which parent they want to live with? There's a conflation of two things in there, but we'll sort of auto-correct them if you like. So we'll just ask the question, does a 12 or 13-year-old have any say on custody? And we'll deal with the other part of it.
After we answer the first part.
Yeah, so
address it.
That's a interesting one, and I had a personal situation with something like that.
Yeah.
But before I talk, I want to hear what you reckon.
What I reckon? Well, I personally believe that a 12 or a 13-year-old is, more than capable of making a decision on what he or she wants to do and who he or she wants to spend time with, which parent, in my opinion.
Okay, so let me put this to you then. Is having, and what you've just said there is very much what the court goes along with, and it's very much in line with the Gillick competency test.
Yep.
Right, where they assess whether a child is competent to make decisions that will impact them long term, and whether they have an understanding, which of course they don't, but you're suggesting they do. So,
I'm suggesting.
Okay. Let me ask then.
Go on.
Does that view then empower or does it make it so that whichever parent is the best manipulator sort of wins?
That's true too. It does happen in that way. Yes, very true. That does happen very regularly, and because children are always in the mother's, custody more than the father's.
Yes.
They're able to obviously. I'm going to use the word manipulate.
Yeah, well, influence.
Influence.
So are you then, for the audience out there, are you retracting?
What? No, I'm not retracting nothing.
That's right. Apologise for nothing, retract nothing.
Exactly.
And we just hope that you haven't construed those legal advice, because...
It's not legal advice. It's just experience. You've experienced it firsthand.
I have, and that's... this issue to me, so does a 12-year-old have a say on custody? They currently do, and I can't remember the specific provision in the Family Law Act, which talks about the child's wishes, which are going to be considered. I don't believe that that's valid in my mind, and the issue, of course, that my idea runs into is that if we treat children as chattel, right, as property, then as they get older, that doesn't quite work anymore. And I'm talking about 15, 16, 17, all the way up to 18, which is where that ends.
Yeah.
Because they can and will make their own decisions more and more, especially in this particular society that we're living in, which is encouraging individuality, etc.
Yeah.
I tend to push back on that and say, well, no, the child's views should not really come into custody battle at all. And generally speaking, you're not going to have custody battles over a 17-year-old. It doesn't happen.
No.
And maybe the reason it doesn't happen is because of this Gillick test that I'm talking about, which was a case in the 1980s in the UK, where they talked about, as I mentioned, like what age does a child become competent, where they can understand the long-term ramifications of their decisions. And I think that the answer to that is, well, not even till past 18. In fact, you're over 50 and still you don't have any competency.
No, I'm still a kid, mate.
But I wouldn't trust you with a decision of any importance.
Oh, thanks, mate.
I'm just joking, of course. Now, So we'll get to the other aspect of this,
Question?
which well, I mean, it's embedded in there, which is, you know, should they have a say on custody? And this is where I'm going with this, is that well, as I said, I don't think they should. I think that the question is, has there been any crime committed?
Mm-hmm.
Has there been any, you know, abuse or negligence or neglect or these sorts of things? And if there hasn't, then custody is 50-50.
Mm-hmm.
That's where I'm coming from.
Okay, yep.
And you can see that if you start to bring in things like the child's wishes, it starts to basically be a front for the state. Like, that's my view on it, because it becomes who's going to comply the best with what the state says is proper parenting practice. And I don't think that the state has that.
Yeah, the state can't really.
But that's how they do it.
That is how they do it.
Well, that's why. Well, so that's why I was pushing back on your idea that children should have a say, is because when you do that, you're essentially empowering the parent who is most compliant to get the most custody.
Yeah.
And it's the same with this idea of best interests of the child. I mean, you see this littered all the way through every single chat, you know, or post online. They always say, oh, you know, my ex-partner is, you know, he's got a new girlfriend, and, you know, she's a this and this. That's not in the child's best interest. And you see that the people are extending, you know, well above what their authority could or should be. And I would argue that the court's authority shouldn't be that either.
Yeah.
To determine, you know, we talked about this one in the podcast before, where you're talking about, you know, the woman has a new boyfriend, and do we want to check into him? And so this is really an issue of authority and jurisdiction. So we won't go too much more into that, but we'll go and have a look at what the comments are. Let's have a look. So the grey octopus, which we could be any of those. At that age, a child's view carries significant weight, right? And we might just focus on that. Is why that is, and it's because it's not because it's necessarily true or what's, you know, best practice. It's actually just because that is standard procedure. It's the what do you call it? The you know, oh, fucking gone blank. You know, what people do, like the easiest decision to make.
The easiest decision to make.
Yeah.
I called it the
Yeah, I've gone blank.
the path of least resistance is what I call it.
Right, the path of least resistance. So it's not necessarily that the child's view carries significant weight. It's just that that's what people do in practice. Lawyers operate in that way, and then the court operates as per how lawyers frame their arguments. So,
generally speaking, though, in 2026, everybody looks for the path of least resistance.
Well, I think that's a truism at all periods of time. The question then is, you know, what is that path at different points in time? Like in the 1960s, the path of least resistance was to stay together, right? And that's what, you know, feminism, or maybe first or second wave at least, was trying to counter, was that was the, you know, expectation, that was the path of least resistance, and they railed against that. And now we've got everyone just separating.
Off doing their own thing.
Yes. So I'm not sure about that manoeuvre. Okay, so we'll continue on here. So especially as they move... Oh, can you believe this? I got
Phone call coming through.